So that even whether the COC has approved this with 66% voting share or not, we'll have to provide for the same as per section 30 subsection 4. So this will become not applicable, and here we'll have to provide yes. Next, whether the plan has provisions for its effective implementation plan according to the COC. So yes, again, with respect to the effective implementation of the plan, again, this is basically has to be justified to the NCLT. So therefore, this depends on whether the monitoring committee has been adequately constituted and all that stuff, which has to come there. Next, with respect to the regulations. Now, after the sections, now the regulation 38, 39 will come into picture. Under regulation 38, subregulation 1, it talks about the priority in payment over FCs. Now, in majority of the resolution plans, this terminology might miss, but the regulation reference might still be there. So we have to be double careful as to which clause, which relevant clause is talking about this. So that clause reference has to come. Then the plan includes a statement as to how it has dealt with the interest of all stakeholders. So we need to clearly provide as to what is that clause which deals with the statement. Similarly, we need to go whether they failed in implementation or contributing to the failure of implementation of any plan. No, then where is the clause which states that they did not? Whether the RA has submitted a statement giving details of such non-implementation. If at all yes, then whether they have given non-implementation details, then in which clause? And regulation 38, subregulation 2, what is the term of the plan, right? What is the term for which the plan is valid? The implementation schedule, all of this, where is it provided in the plan? The clause has to come. Similarly, management of the business of the corporated during the term of the plan. Adequate means for supervising the implementation, which clause is it provided for? Whether the plan demonstrates that it addresses the cause of default or not, that clause has to come. It is feasible and viable, whether it is demonstrating it or not, that has to come. It has provisions for its effective implementation, right? Whether the plan has the provisions for effective implementation or not, which clause is providing for that? Approvals, capability to implement the plan, and then whether the RP has the RP has filed application in respect of transactions observed, found, or determined by him. Now, these are avoidance transactions, right? So the idea is to see whether there have been such avoidance transactions for which we have filed the applications or not is something which has to be looked into. Next, details of performance security received as referred to in 36B4. Now, this performance security details has to be clearly provided for. That along with the resolution, after the approval of the resolution plan by the COC, after we would have issued the letter of intent to the successful resolution applicant, the successful resolution applicant will be asked to provide for a performance security. Now, this performance security might have been in the form of a bank guarantee or a direct deposit or a DD. So a description has to be clearly provided for that. This is provided by way of a bank guarantee, number so and so, dated so and so, issued by so and so bank, right? Or you can provide a thing like, this is being provided by way of a direct deposit into the company on so and so number by way of a UTR, unique transaction code, or whatever number so and so, so and so. So a description to that effect is extremely important. So this is how para number 9 deals with the compliance of, this is the major part of the plan, because the compliance certificate is on whether the plan is compliant or not, right? So para number 9 deals with that. So that has to be clearly taken care of in para number 9. Coming to para number 10, whether the CARP has been conducted as per the timeline indicated. Now, what is the timeline? So we have a specific model timeline under the CARP regulations. So based on that model timeline, we'll have to provide what is the actual timelines which we had incurred. The CRP has been conducted as per the timeline indicated. So what are the timelines? First, commencement of the CRP, appointment of that date will be there. Your publication date, claims submission, what is the last date? These are all the actual dates which you have to provide for. These are all self-explanatory, not going much into individual details. But there may be a situation where you have multiple dates, right? So as I informed, let's say for invitation of EY, you would have invited it like thrice, then provide all the 3 dates, first, second, third. And similarly, your publication would have been for 3 different dates, provide that. Provisional list for 3 dates, provide that. Final list maybe for multiple dates, provide that. So you need to be correct in terms of what you're disclosing over here, over this. And same goes with your RFRP EM. You would have issued it multiple times, give those dates. And finally, submission of COC approved resolution plan. Now, this is again a futuristic date because at the time you're signing this Form H, you wouldn't have filed the resolution plan because this goes along with the IA to be filed for approval of resolution plan. So we have to keep both hand in hand and file it with the NCLT. So this is something which has to be, the date has to be clear. And finally, approval of resolution plan. Like this is a date which we have no idea of, so we'll leave it blank. Now, the time frame proposed for obtaining relevant approval. So in the resolution plan, if at all the plan provided for the details of these authorities from whom they will be obtaining the approvals, then you need to provide the table clearly that this is the nature of approval, this is the name, and all these details based on what is provided in the plan, right? So this has to be something which is provided in the plan. Right. Next, the resolution plan is not subject to any contingency. Now, this is something which is, a tricky thing. If you see 12, there are 2 options. One, you have to declare that it is not subject to any contingency, or number 2, you have to provide that this is subject to the following contingencies where we have to elaborate the contingencies. Now, typically, a contingency situation arises. So what exactly is a situation of contingency? Your plan may not actually provide that so and so is a contingency, right? But it would have provided for a situation what would happen if there is a contingency. Let's say a resolution plan is provided for completion of construction of a real estate project. Assume all the creditors are only home buyers, but there is a dispute to the title, right? Now, if the dispute goes in favor of any other party, then there is no asset at all. So as a resolution applicant, I am just stuck without me getting any asset in return. So therefore, I will definitely provide a contingency that my plan will be subject to the condition that this litigation, which is pending before any civil court, is passed in my favor. But having said that, there are multiple NCLT orders, particularly in NCLT Bengaluru, where conditional plans have been rejected on the ground that there is a condition or a contingency. Now, this is completely contrary to each other. If you see this para number 12, it basically provides a column where I can elaborate on what are all the contingencies of a particular plan. But quite ironically, the NCLT is not entertaining a plan because it feels in its opinion, it's a conditional plan and the plan cannot be conditional. If that is the case, then this never should have come at all, right? This providing for what are the contingencies should never have been made part of the format. But yeah, that's how it is, right? So it's still not clear like how the conditional plans has to be looked into. But what are those conditions? What is the contingencies? I think the nature of contingency is extremely important before NCLT can decide on whether the plan can be proposed for voting or not, right? So that's something which we'll have to look into. Then going forward, para number 13. Now, in para number 13, we need to see what are all the deviations or non-compliances in terms of the code. So this is particularly from the RP's point of view. This has nothing to do with the plan, right? So we need to provide what is a particular section or regulation which mandates us to do something, whether we did that or not. If we fail to do that, then what is the reason for it and whether we have rectified it or not. So usually we would have delayed in filing a particular form, or we would have delayed in appointing registered valuers, or delayed in filing of IA for avoidance transactions. So it is the best way to provide all those details here and explain why there was a delay and whether we have rectified it or not. So rectification is, yes, even if there's a delay, it's still rectified it by filing that particular form or by filing that particular application with the NCLT. So that way, we have to provide for all those details as part of this table, right? Next, para number 14. The resolution plan is being filed dash days before the expiry of the period of CARP provided in section 12. So you would have filed 5 days, 10 days or something like that. So then you can provide so and so number of days before the expiry. Then 14A, whether the plan has in accordance with 35A. So this is talking about again the avoidance transactions part with respect to CARP 8. There are two things applied to the NCLT on or before 135th day of the ICD. So whether did you file an application for avoidance transactions and before this date, yes or no, or filed form CARP 8 on or before 140th day of the ICD. So whether a CARP 8 has been preferred or not, these are the two things which we'll have to look into, right? So yeah, so these two things we'll have to check whether what based on the factual data, whatever it is. Then provide details of section 66 or avoidance application filed or pending. So under 43, 45, 50 and 66, what is the date when you filed? When did you get an order? What is the brief of the order? If the order is not yet passed, then you can say not applicable, not applicable. And if you say the applications are pending, you can leave a note below that the applications are pending, right? Next, 15A, right? So 15A, it talks about the estimated liquidation cost. Now, this is under Regulation 39B. Now, Regulation 39B provides for a situation where the COC is considering approving a plan or approving for liquidation. At that scenario, COC should also discuss on the plan for providing for contribution under Regulation 39B. Now, that is, if at all the company ends up in liquidation, who is going to contribute and in what manner are they going to contribute? That comes under that. So, in that estimated liquidation cost, what is the amount? Liquid assets available. What are the assets available for you? Then contributions required to be made. What is the amount of contribution you need to do? And financial creditor wise contribution. Who is the financial creditor? What is the amount they'll have to contribute? So this way, we'll have to provide all these details. At times, it may so happen that the COC would have rejected this. Then we'll have to provide it very clearly that COC has rejected this in its meeting. This was proposed for approval, but the COC rejected it, and therefore this all becomes not applicable. So that way we can do a exercise on giving these details clearly. Next, 15B, the committee has recommended under Regulation 39C as under the sale as a going concern, yes or no, sale of business of the CD as a going concern, yes or no. The details of recommendation are available with the RP. Now, so again, under 39C, the committee again at the same time when they're either approving a plan or approving a liquidation, they can also recommend whether to sell the CD as a going concern, either as a CD or as a business. If the committee voted in favor, you will say yes. If not, you'll say no. Similarly, 39D, it provides for fixing the fee of the liquidator. Did the COC do that? Yes or no? If yes, so here it says the committee has fixed in consultation the fee payable under Regulation 39D. If COC did not do that, then you'll have to say not applicable because the COC has rejected this particular resolution. Such kind of a note can be provided for. Finally, you are basically certifying this contents to be true. It's like a verification clause, and that's all. It ends here. So this is all about Form H under CIRP regulations. It is a meticulous form trying to summarize the details from end to end with respect to CARP, with respect to the CARP of a particular company, right? So if there are any questions, please feel free to ask. Okay, fine. Then I'll move forward with the compliance certificate under the liquidation regulations. I'm assuming there are no questions asked. In the chat box also, I can't find any questions. So yeah, I'm moving forward. Yeah. Okay. So now let's start the compliance certificate under the liquidation regulations. This compliance certificate goes along with the IA for dissolution or IA for closure of the process, either of it. Right. So this is again a compliance certificate which is provided as a which is provided as part of the liquidation regulations, and the liquidator is obliged to provide all these details at the time at the time the liquidator is filing the application for dissolution or for closure of process. So in the compliance certificate, the details of liquidation process are as under. So this basic details like name, the case number, NCLT bench, date of initiation, appointment, commencement of CARP, the initial process, who is the RP during the CARP and the registration number, name of liquidator and the number, publication of public announcement under Form B, that is under the liquidation, when did you publish, the date of intimation to registry and IU, if any, about commencement of about commencement of liquidation. So when did you file this INC 28, and information with the information utility also with respect to commencement of liquidation. Date of handover. Date of handover. The date of handover also has to be provided. Handover of charge by RP. Suppose if it's a different RP, you are not the let's say you are not the RP who is handing over the charge, then I mean, like, you are taken charge as a liquidator from another RP, then the date has to be provided. If you are continuing as an RP as a liquidator and you were the RP before, then it will be the same date when you were appointed as a liquidator, right? So that will come here. Then date of submission of complaints, if any, directed by NCLT, adjudicating authority, in the liquidation order and its particulars. Now, submission of complaints, if any, as directed by the AA in the liquidation order and its particulars. So, if at all any NCLT had given any directions of complaints in the liquidation order, that has to clearly provide for this, that when did you submit the complaints. Next, date of appointment of valuers, if any.
1 minute, sir.
Yeah.
For point number 11, please explain what kind of compliance to be given.
Yeah, sure, sir. Sir, usually NCLTs, in addition to the progress report, which we will submit quarterly, NCLT would have directed the RP that, okay, you submit the complaints that the applicant had received. Let's say the NCLT directs the applicant to deposit 2 lakh rupees as initial expenses. Okay. And subsequent to that, the NCLT would have given one line saying the RP shall submit the complaints of the same to the NCLT within 1 week from the date the amount is deposited to the liquidator. So that way, the liquidator would have been directed to do some kind of a complaints. Maybe, or this is one part of it. Second, probably the liquidator, suppose there are numerous home buyers who are involved in this case, right? So maybe the NCLT wants monthly updates. instead of quarterly updates. Now, NCLT may direct such kind of a submission to the liquidator. Now, usually they won't in terms of progress reports, but if at all there is any such order provided by the NCLT in the liquidation order, so usually it will be to the fee to be payable by the COC or applicant, then NCLT will want the liquidator to file for a compliance report on it so that the NCLT will know whether this has been done or not. So such kind of things come here, sir. So so here you need to provide the date when you have submitted such complaints with the NCLT.
Okay.
Yeah. So it's not any specific, it will vary from case to case. So usually these days, we don't see this coming in liquidation orders. We see, usually it will be in the CIRP commencement only. In liquidation commencement, because they are now strictly indicating what has to be the process as per the liquidation regulations, there is nothing much we need to worry on this. But if at all there is any, then we need to provide those dates here. Thanks for asking that. And as we move forward, date of appointment of valuers, similarly what we saw in Form H under CIRP, that will be coming here. Then date of notice for uncalled capital or unpaid capital contribution. Now, this requirement under liquidation regulations is that, so typically a equity shareholder is liable to the extent of paid up share capital subscribed by such equity shareholder and not paid. Okay. So a paid up, so let's say I've subscribed for 100 shares. Each share is 10 rupees issued at 10 rupees. So total 1000 rupees is what I should have deposited to the company. Let's say I only deposited 600 rupees. It's uncalled. Okay. The balance 400 is uncalled, or it is called but unpaid, the balance 400. In either of these situations, as an equity shareholder, I am liable to infuse that money into the company, even during liquidation, because that is my liability. My liability is limited, yes, but it is limited to the extent of me subscribing to the shares of this company as an equity shareholder. To that extent, I will be held liable irrespective of the time zone the company is, be it liquidation or not. So as per our liquidation regulations, we need to send a notice whenever we observe such kind of unpaid capital or uncalled capital. So that date shall be provided for there. Then realization of uncalled capital or unpaid capital contribution. Again, this contribution is from the contributors, nothing but the equity shareholders. When did you realize it? Then the date thereof. If we could not realize, then we need to leave a note that this could not be realized because of so reasons. Next, date of realization of date of opening of liquidation account with bank account details. Now, so we are technically, we need to open a liquidation account with a scheduled commercial bank. Because that's the account where we record receipts and payments. So that also has to be clearly provided for. Then date of opening of date of constitution of consultation committee. With respect to constitution of consultation committee, the timeline we have is pretty huge, because 30 days timeline we have for submission of plans, and another 30 days we have is for verification of claims, and similarly 60 days is the total timeline from the commencement date, which is provided for constitution of the consultation committee. But till the time you constitute the consultation committee, the existing COC will function as a stakeholders consultation committee. So that also has been clarified. So therefore, when did you first constitute the consultation committee has to be provided for. Number of meetings held till date. What are the total number of meetings of consultation committee held? Date of submission of list of stakeholders to the NCLT. When did you submit the list of stakeholders to the NCLT? That has to come. Date of filing. So earlier we were supposed to provide for date of filing of preliminary report and SS memorandum. Again, this is the filing which you have to do within 75 days. So that has to be clear. And then fair value of the company and liquidation value. We have seen under CIRP regulations format. So similarly, if it is the same, let's say you are utilizing the same valuation report which you have utilized during CIRP, then you will provide the same values. But or if you are utilizing different values during the liquidation because of the liquidation order, let's say you have appointed values afresh, or you have done a new valuation after the liquidation order has been ordered for, then again those details has to come here. Then date of public notice for auction, right? Now it says please add additional rows if required. Usually it is like if wherever we are going for multiple auctions, right? So all the dates of that respective public auctions has to be clearly provided for. The dates has to be provided, and particularly the sale auction notices 1, 2, 3, 4. It may be for going concern sale, standalone sale, anything. All those dates has to come. Next, date of order of NCLT to dispense with the public notice of auction. Now, wherever we would have applied to the NCLT for dispensing the public notice for auction, because it is again it's a requirement under the regulations where we have to apply to the NCLT, only then we can get it dispensed. So that date of order will have to come here. Then if we are going for a physical auction, if we had a physical auction, then did the NCLT approve? Then what is the date when it has approved? Similarly, you did a private sale. When did the NCLT approve the private sale? Next, there are certain unsold assets, right? So there are certain unsold assets which you want to distribute. Now, when did the NCLT give you an approval for distributing such unsold assets to the stakeholders? So all this has to be provided for. Then permission of the liquidator to realize the unrelinquished security interest by the secured creditor, right? So again, so wherever a secured creditor is realizing is requesting to realize the unrelinquished security interest, right? So in such a situation, the permission of the liquidator has to be sought for, so that date has to be provided. And then list of stakeholders, whenever you have modified it and when did you submit to the NCLT, give the dates and the submission to the NCLT. Date of first realization, when did you first realize a particular sum of money, then second subsequent realizations, etc. First distribution, second distribution. So it's like a seriatim. You realize when did you distribute first. So different distributions you had, then give different dates. First different realizations you have, then give relevant subsequent dates. You can add columns also here. That if you had multiple distributions or multiple realizations, you can keep on adding the columns there. Sorry, the rows there. Then date of submission of quarterly progress reports, report number 1, right? And then asset sales report wherever a sale is done. And then other progress reports 2, 3, 4, and along with the progress report 4, you need to provide audit report, that date. And similarly, if your process is going beyond a particular, like it's extending beyond 1 year, then for subsequent year also, when all did you submit a progress report, all that has to come. Next, date of intimation to statutory authority. Like whom all did you inform? PF authorities, ESA authorities, income tax department, inspector of factory, GST, etc. All those intimation dates has to be clear. And the moment I say date, you also please note that as a backup in your system or as a physical copy, you need to have a backup of the documents which will evidence this particular dates, right? So the documents based on which you are providing these dates has to be available with you. That is how you have to prepare these kind of forms. Then date of depositing unclaimed dividends or undistributed proceeds and income and interest thereon to the IBBA. So IBBA has created a corporate liquidation account. So in an event where there are certain unclaimed receipts, unclaimed amounts, like there are some creditors who have not claimed the monies, or undistributed proceeds, for some reason there are certain proceeds which could not be distributed, right? So all these, when did you deposit, such date and the details you have to provide in this table. Then amount deposited into corporately. So based on in para number 44, we are providing for date of deposit, and para 45, we are providing for amount deposited into corporate liquidation account. Next, with respect to this amount deposited into corporate liquidation account, we'll have to provide what is the amount of unclaimed dividends, undistributed proceeds, like what is the total amount of undistributed proceeds, and of course, what is the income we have referred to this, and also the interest whatever would have gathered from this. So it has to be clearly provided for. Then date of submission to the board and the authority under 46(5). So there's nothing but this form. When will you submit? When are we submitting it to the IBBA as well as to the NCLT? That has to come. And the final report to the NCLT. Prior to resolution application, we file a final report. When is that dated? So these are again factuals based on the particular scenario. Now comes the critical information, right? So from here on, what all information we proceed deals a lot with the money. I mean, it is a lot with figures, right? So therefore, see, in CIRP, it is more of data, dates, but in liquidation, it is more of money. Because you are trying to explain what was the assets you had and how did you, sell it? What was the receipts and payments you're maintaining? All of it has to clearly come in the Form H under the liquidation regulations. So first, the details of assets as per asset memorandum and final sale report, right? So what are the assets the company had? Mode of sale. What mode you have sold this, right? So in the mode of sale, we have different modes. Like you can do it through standalone sale, slump sale, or in parcels, or you can do it collectively, or you can with any other assets, or you do it as a going concern sale or business as a going concern. Everything has to be clearly identified. Even the manner of sale, if you want, you can add. That is, it's a private sale or a public sale, also has to be clearly provided for. Then estimated liquidation value. What was the estimated value? So estimated liquidation value is nothing but the value as per the valuation report prepared by the registered valuer. So that has to come here. Then realization amount. What is the actual realization amount from the sale of asset has to come here. Then the date of transfer to liquidation account. When did the amount transfer to the liquidation account has to be clearly provided for, right? So date of transfer to the liquidation account. By when the amount was transferred to the liquidation account has to be clearly provided, so that is the actual date you got the money into your account, right? Right. Next, as we move forward, with respect to liquidation value of the, okay, so in para number 3, if you have multiple assets, for each asset, each row you'll add and provide all these details. Now, para number 4, liquidation value of the liquidation estate. So again, you are providing the liquidation value based on the valuation report provided by the valuer, and you're giving the total liquidation value there. Next, amount realized during the liquidation process. So what all amounts you have realized? Opening balance as on LCD. There may be certain accruals of the company or cash balance in the company that comes as an opening balance. And realizations. Auction of assets, you would have sold the assets, right? Based on that, from the auction, you would have received certain money, or you would have done a private sale. From that, you would have received certain money, or you have assigned not readily realizable assets. From that, you would have received certain money. And distributing unsold assets, there will be a value for the unsold assets that also will come here. And others, if there's any other mode like recovery from receivables, right? So any other mode by which you would have got the money, that will be provided, and the amount will be attributed to that relevant row. And finally, all this will be added up to provide for the total amount which is being realized, right? So that is what is under para 4, which talks about the amount which is being realized. Next, amounts distributed. So on one hand, it's talking about amounts realized. On the other hand, it's talking about amount, how did you distribute it? Some amount would have gone towards the CIRP cost, certain amount towards the liquidation cost, and then finally in the order of priority under section 53(1)(b)(1), which is secured creditors, sorry, workmen, B2, secured creditors who have relinquished security interest, then C, D, E1, E2, F, all this, are the stakeholders in the order of priority under section 53. So in the same order, we have to explain what is but it's only category, right? It's not an individual creditor. It's a category of those creditors. Secured creditors, workmen. Overall, what is the amount claimed? Overall, what is the amount admitted? Overall, what is the amount distributed? Now, whatever you would have distributed should have fallen strictly in line with section 53. That's what is the intent. And then amount distributed to the amount claimed, again a percentage, and the remarks. So this is basically again a similar thing which we did in CARP regulations, that Form H, but here the distribution has to happen in the same fashion or in the same flow in the waterfall mechanism provided as per the order of priority in section 53 of the Insolvency and Bankruptcy Code 2016. So this is with respect to 4C. So para 4 talks about liquidation value, realizations, and distributions. Now, as we move forward, 4A. So 4A talks about the realization of security interest by creditors, secured creditors under section 52. See, under 52, the secured creditor would have relinquished its own security interest. Then who are such number of creditors who have not relinquished the security interest? Then liquidation value, what is the value of such security interest, who have not relinquished it? right? So they never relinquished it in favor of the liquidation estate. So they are excising it. Then what is the liquidation value towards it? And what is the amount of such admitted claim of that particular secured creditor? So the creditor who has not relinquished the security interest, that creditor's amount of admitted claim, it may be multiple. Then if suppose 3 such creditors are there, then aggregate of all of it. Then total realization, how much did they realize from the sale? It's their obligation to inform you. So that realization also has to come. Total contribution made as per regulation 21A2. What is the contribution they have made as per regulation 21A2? And then contribution made by secured creditors towards workmen's dues. Now they also see, just because they have realized the security interest on their own does not do away with the obligation under section 53. So they still will have an obligation to meet the CARP cost or liquidation cost, and other contributions which they have to make towards workmen dues has to come there, and also towards, of course, CARP and liquidation cost. So those details has to come, and excess of the realized value of the asset. After meeting this contribution, what is the excess, right? And realized value received by secured creditor, that is after actual realization minus all this will be the realized value which is received by the secured creditor, and date of such realization. When did they realize it? Now, these are all details which the secured creditor itself will provide. Only thing is these calculations under 5 will be critical in this table. And finally, 4B, which is details of assignment of not readily realizable assets, NRRA. Now, for this not readily realizable assets, we need to provide the details of the assets, and then liquidation value. What is the value of the liquidation value of these assets? Amount realized, bidder. Of course, who is the bidder who has successfully got this NRRA assigned in their favor? Sharing of proceeds between bidder and creditors or corporate debtor. How was it being distributed? Like suppose let's say this NRRAs currently they are not readily realizable, but at a later date with some level of investment you may realize it. So that being the case, what are the terms of the assignment? Will they be if any proceeds are coming, will they be distributed back to the creditors, or how is it? Is something which will come here. And then schedule of realization by bidder. So how can the bidder realize these kind of assets? All those schedule can also be provided for. So these are again very peculiar for few cases. Not in all cases will we get this kind of a situation. Right. Next, the liquidation process has been conducted as per the timeline. Now, again, this is similar. Whatever timeline we have seen in the CARP regulation, a similar replica, but over there we had a complete model timeline. Over here, they have only given a small table, but we have to build on this. All what is provided in the model timeline, right? So this is quickly for your, yeah. So this is the 47 model timeline. This table we have to provide for, and then these timelines we have to provide for in that column, and to the right of it, we have to explain what exactly is the date when we complied with it, right? So it's again an exhaustive table, which we have to prepare as part of our complaints. Yeah. So the timelines front has to be clearly laid out. What is the timeline as per regulation and what is the actual timeline, right? Yeah, moving forward. Again, this is a similar replica of what we have seen in CARP regulation, so I'm not commenting on this. But just to quickly recap, whatever non-compliances we would have done, better to list it out and explain the reason why this had happened. And we would have rectified it, then clarified that it is rectified and what way we have rectified it. So this is a clear, it sets the record straight in the knowledge of IBBA. It's moving forward, para number 7. The dissolution application has been filed. So and so period before or after the expiry of 1 year, whatever is the timeline when you file this has to come here. And if there are any extensions sought, which we would have sought, like more than 1 year when we have done, what was the date when the extension was sought, whether it was granted, and what was the reason for which the extension was sought has to come in this para 7. And then para 8, avoidance transactions. When did you file? What was the order? And what was the brief date of the order and the brief of the order? So this avoidance transactions also has to be clearly provided for. Then all undischarged or matters pending before any court or tribunal relating to the corporate debtor, if any, have been reported to the adjudicating authority. Now, the reason why this is being provided for is adjudicating authority is once for all dissolving the corporate debtor. By dissolving the corporate debtor, the entire company existence is gone from the records of the register of companies. So therefore, it is a big step, right? It's a death of the company. So the NCLT has to know what all matters are undischarged or which are pending against the company or in relating to the corporate debtor. Now, this should have been informed to the NCLT in any form. So typically in the final report, we do it. So that has to be referred to. That's a declaratory statement which we have to make. And then name of liquidator, we certify the contents. Again, it's a verification clause where we are certifying the contents of this certificate. So this is the compliance certificate for the liquidation process in Form H. So this provides for all the details right from the date of commencement of liquidation process till the date the assets are being sold. So a clear record of all these steps has to be maintained by the liquidator, and whatever assets are being sold, the details, assets which are, this is a complete, it's a final report, right? So all assets would have been sold. So listing out all the assets and the mode of sales is extremely important. And also you need to maintain your own records on what amounts have been realized and distributed. So that also will come as part of this form. So that's about it in terms of compliance certificate in the liquidation regulations. So any questions from anyone on this compliance certificate? Feel free to ask. Anybody on the compliance certificate under the liquidation regulations? Okay. Now let me just take you through the liquidation. I mean, so the regulations, the voluntary liquidation regulations, where there is a requirement of a compliance certificate. I'll quickly show that it's more or less based on it is more or less based on what we have submitted in the liquidation regulations. So this is under the voluntary liquidation regulations, right? So under voluntary liquidation regulations, the liquidator is a kind of appointed by the shareholders and not by the NCLT. So therefore, that liquidator who is being appointed by the shareholders by way of a special resolution will submit this compliance certificate and the final report to the NCLT at the time of dissolution. So similar details, when did the voluntary liquidation process begin, which is the date of special resolution, date of special resolution, date of appointment, again, the similar liquidation registration was replaced. If yes, then what is the process? Then name of previous liquidator, if at all it is being replaced. When did you open a bank account? Notice for uncalled capital or unpaid capital contribution. Again, we have seen this realization, intimation to authorities. If there is if there is unclaimed amounts, then when did you deposit into corporate voluntary liquidation account? Now, see, the entries are pretty low, right, compared to what we did. So if you see the liquidation process regulations, we have had a plethora of information on progress reports and all that. Whereas in voluntary liquidation, all that has wiped off, right? It's simple. And remuneration of liquidator. What is the remuneration at which the liquidator is being appointed? That also will come here. Then details of the corporate person, that is about the CD. When was it incorporated? What are these objects? Paid up capital, asset size as on the liquidation commencement date, debt payable, net worth, reasons for initiating voluntary liquidation in brief. Now, as we all are aware, voluntary liquidation is a situation where the company is solvent. right? So the directors declare solvency by stating that the company is in a position to repay all its debts. But what is the reason for initiating? There may be a foreign company which had a subsidiary in India. They want to shut down their operations in India and move back to their home country. That can be one reason. Second reason is that the objective for which the company is incorporated is accomplished, right? So similarly, whatever. Sorry. Yeah. So whatever be the reason, that has to be clearly provided for, and that comes as part of this statement. And that's where, if you see how they have stated it, the asset size, debt payable, and net worth. So based on the asset size and net worth, it can be seen whether this debt can be payable or not. So that's how this comes into picture. Details of realization during voluntary liquidation process. How did you realize the assets? The sale of assets, like what is the total amount you have released from sale of assets, or any refunds from income tax or statutory authorities? What is the cash balance you already had? If there was any uncalled capital, what is the amount which has come back? Distribution of this unsold asset and any others, whatever you can specify there. And details of distribution to stakeholders as per section 52 or 53 of the code. Now, how did we distribute? Again, similarly, if it's a realization of security interest under 52, the creditor themselves are realized, then what was the amount they claimed, admitted, and distributed to them, which is nothing but what they've realized. Under 53, this we have already seen again. In the same order of priority under 53, similar details which we have seen there comes over here also. And it is conducted as per the stipulated timeline, whatever be the timeline, right? As per this regulation was or the section, whatever the timeline or the norm they provide for, and what is the compliance date you did, and actual timeline, which is the number of days which you have taken. So that way you will have to provide for each of these steps, which are the basic steps for the entire liquidation, voluntary liquidation process, right? So all these steps will come into picture. Then deviations, again, similarly, as I was explaining, wherever there is any non-compliance with any of the provisions of the code, you need to list down such non-compliances and provide the reasons and rectify the same. This is a good practice always, in my opinion. And then avoidance transaction details under section 43, 45, 50, and 66. What all you have filed and what dates, the order of the NCLT and the brief of it has to be provided. Where the process has taken more than 90 or 270 days, as the case may be, then the reasons thereof, why did you take so and so number of days? And then all discharged matters pending before any court or tribunal relating to. Yeah. So yeah, all courts or matters, tribunals relating to corpses. Again, the same thing that we have already provided for such kind of a disclosure that has to come. Then records referred to in regulations 8 and 10 shall be preserved as mandated under regulation 41. Again, this is a mandatory requirement to maintain the records by a liquidator. So again, a declaration to that effect that it will be preserved. And any other information which the liquidator may like to submit. Now, see, this is missing in our liquidation regulations or in the CIRP regulations. There is no such clause which kind of says any other information, right? Because these two are strictly provided formats. There is nothing which is additionally which you can give, but still the idea is where such additional information will help the NCLT in understanding the information disclosed in this form, definitely you should be in a position to add it. While in the voluntary liquidation, it is specifically asking. So in voluntary liquidation, you have to give under this clause 12 or this para 12, you have to give all the other details which you want to inform to the NCLT. So all of it can come here. And finally, the verification clause in clause 13. So these are the three compliance certificates, right? They have all the three are Form H only. One is under insolvency resolution process for corporate persons regulations 2016. That is in the CIRP regulations Form H. Then one is in liquidation process regulations Form H, and the other is in voluntary liquidation process regulations Form H. So the three Form H, all the three are compliance certificates which we have to submit to the NCLT at different stages, so depending upon what is the process. So that's about it from my side. If there are any
small question, sir.
Yeah, sorry. Go ahead, sir.
See, actually, what happens? Final certificate is to be submitted first.
Final report, yes.
Final report.
Yeah.
After that final report, we have to submit the liquidation. That is the order, no?
Correct. After final report, we will file a dissolution application along with final report as well as the compliance certificate.
No, the problem is, sir, there may be some objections or observations by NCLT, and if we submit after approval of final report, that may be useful, or we can file together, all of them together.
Sir, ideally, we file all of them together because
Okay, sir.
once we file all of them together because if you see the dissolution application, it says a dissolution application shall be submitted along with final report and compliance certificate in formats to the adjudicating authority.
Okay, sir.
Right. So it is like it's a single application where we also enclose a final report and the compliance certificate.
Okay, sir. Thank you. Thank you very much.
Yeah. Thank you.
I have a question, but may not be directly related to it. But
Yeah.
at the end, when we go for filing dissolution application and check our compliances,
Yes, sir.
I wanted to check this form E is there, no? When that amendment had come,
Then try to, sir,
where whatever value of the resolution plan and the fees paid to professionals, 1% or something is to be paid to the IBBI.
Form EA. Okay. Yeah.
So if I have read the regulations, they only refer to the CIRP regulations.
Yeah.
That doesn't apply to liquidation, right?
Yes, absolutely, sir. It's only till the CIRP process that Form EA, the regulatory fee is applicable to be paid to the IBBA. But unfortunately, when we fill the Form EA, it also provides in the drop down the option of liquidation.
Yeah,
But
that is the confusion. So
Yeah,
I
yeah.
just wanted to clear that because law doesn't say so, just
No,
that
it doesn't.
form is
Yeah.
there. So I just wanted to confirm.
I think probably because of their coding whatever they had, maybe the drop down is auto populated. But you are absolutely right, sir. As per the regulation, it is extremely clear. It is only provided in CARP regulations. There is no such clause in liquidation regulations or voluntary liquidation regulations. So it's only applicable for CARP, and even in the CARP regulations, there is no mention of liquidation when it comes to regulatory fee. So we are very clear on that. We are on the same page, both of us,
Yes.
that we need not pay anything during liquidation, sir.
Sure. Thanks a lot. Thanks.
Thank you. Yeah. Any further questions from anyone? Okay, great. Anjali ji or anyone from ICSI IIP, we may wrap up the session. We are done with the presentation and whatever be the limited questions we have addressed. Yeah.
Yes, we can close the session.
Yes. Thank
Okay,
you.
sir.
Thank you
Thank you,
everyone
sir.
for the participation. Thank you so much.
Thank you, sir. Thank you for sharing your experience and making this session so interactive and insightful.
Thank you.